Probably most appropriate to start with some background in terms of how the CFTC, the Commodity Futures Trading Commission, got involved with this space. Back in December of 2014, then CFTC Chairman Tim Massad, who was the Obama chairman of the agency, stated in congressional testimony that derivatives based on virtual currencies were within the jurisdiction of the CFTC. That basically meant that the CFTC was interpreting virtual currencies, including Bitcoin, as commodities. That interpretation gave the CFTC basically three primary methods or jurisdiction over the trading of derivatives and in the spot market, the physical market, which is what we call the environment to transact the actual commodity. So from a trading perspective, the agency needed to make sure that trading in any derivative based on a commodity followed the Commodity Exchange Act, the CEA, which is our agency's guiding statute, as well as commission regulations that the commission had issued. We also have to make sure that if there's trading in the underlying commodity that affects retail participants in a certain scenario, basically involving look-alike transactions that appear to be physical transactions but are in fact somewhat similar to futures transactions, that we have jurisdiction over that. And finally, from an enforcement perspective, over fraud and manipulation in the spot market itself, in the physical market itself. So about 9 months after Chairman Massad made that declaration in front of Congress, the CFTC pursued an enforcement case against a company called Coinflip, whose platform, Derivabit, had offered options on Bitcoin itself, but was not registered with the commission. So we had a platform that was engaging in derivative trading of a commodity, but was not registered as an exchange. So the commission filed and settled charges against Coinflip for that activity, and in the process declared in that case that Bitcoin itself was a commodity and the commission had jurisdiction over it. Soon after that, the commission filed and settled a case against a company called Bitfinex, which is a Hong Kong-based exchange for providing transactions in a commodity to retail participants in the United States that used margin leverage or finance. This was a provision known as the retail commodity transactions provision that was added to the CEA and Dodd-Frank, that basically wanted to make sure that if someone was selling a commodity in a look-alike way to a futures transaction, that they were registered with the commission as essentially a futures broker, what we call a futures commission merchant in FCM. And Bitfinex had been selling Bitcoin to retail investors using margin, leverage, or finance. And as you'll find in most cases with the law, there are exceptions. In this case, the exception to needing to register through engaging in that type of transaction is whether or not the commodity is actually delivered to the buyer within 28 days. So the CFTC made a claim that Bitfinex had failed to actually deliver virtual currency to the buyers because the Bitcoin was being stored in Bitfinex's own private wallet and they had their access to their own private key. That's something that I would consider as making policy through enforcement. That's not something generally that I, as a regulator, think is a good thing. I think it's incumbent upon regulators to try to draw some bright lines, and in the case where we don't draw bright lines, to at least provide a test for the market to try to understand where we're falling down on specific rules, how we might adjudicate a specific outcome. Even though I do agree with the conclusion of the case, I think in this case it was fairly obvious. But moving forward a little bit till December of this year, of this last year, December of 2017, the commission has actually come out with interpretive guidance or an interpretation around the actual delivery of virtual currency. And it's based upon a standard that we've used in the past that revolves around independent possession and control. Do you independently have the ability to go in and possess the commodity itself? And do you have the control of being able to use that commodity as it's intended in interstate commerce? And so that basically allows us to make facts and circumstances conclusions on a case-by-case basis. And it's open for public comment. Those comments are due back to the agency in March. And we're going to consider those and hopefully develop a good standard for actual delivery so that people who are engaging in retail transactions and financing them or providing margin or leverage know what constitutes actual delivery. Moving forward again to December, the world changed for the CFTC when both the CME Group and CBOE offered futures contracts and listed futures contracts on Bitcoin. And the method by which they did that almost became more important than listing the contracts themselves. They used a process in the Commodity Exchange Act called self-certification, which was included in the Commodity Exchange Act by the Commodity Futures Modernization Act, CFMA, in 2000. Prior to 2000, the Commission had to affirmatively approve every new contract that was being listed at an exchange. And from 1922, which was when the Grain Futures Act was originally created, we have a history of agriculture in the commodity space, commodity futures space. In fact, our committees of jurisdiction are not the finance or the banking committees, it's actually the agriculture committees of the House and the Senate. The Grain Futures Act of 1922, up through 2000, there were only about 800 new contracts that were listed by exchanges. After self-certification was included in the CEA, between 2000 and the current day, 12,000 contracts were listed. And I think that's an important point. I think it's important because it allows the market to be responsive to risk management concerns. It allows it to be responsive to innovation. And it precludes us, potentially me, as a politically appointed regulator, from really looking only at potential downside in listing futures contracts. And if we provide, I think if we provide a good test through the CEA and through our regulations that the exchanges are saying that they meet, we still have the opportunity to review that. But we have to make a declaration that they have submitted a false self-certification in their application. As it was, there was a lot of negotiation and conversation with the exchanges around these futures contracts, a lot of requests for them to engage in information sharing agreements with the underlying spot exchanges that they use to make up their settlement index. They had to monitor and engage in information sharing. They had to agree to examine any anomalies that they saw in the cash marketplace, potentially proceed against those and share that information with the Commission. The margin that we agreed to, that the exchanges allowed for on these contracts is up to 45%. I don't know how many of you are familiar with the margining process for futures contracts, but what we really look at is volatility, daily volatility compared to a margin rate. Looking at margin erosion on a daily basis, because futures contracts are variation margin is exchanged on a daily basis that brings that contract's economic value back to zero. We're not looking at volatility over the course of a week, a month, a year. We're looking at it on an intraday, day, and maybe a 2-day basis. And at a 45% margin rate over the last month and a half, you've only seen one example where Bitcoin's price eroded that initial margin by 50%. By comparison, the WTI contract, the crude oil contract, had 4 examples in the last month where it eroded margin by 60 to 70%. So on a margin erosion comparison basis, which is what we're concerned about.
Sorry. Thought I turned it off. This is margin call.
Yes, you might.
Apologize.
What's the price now? So from a margin basis, that's what we're mostly concerned about. I think maybe I'll stop there and save some questions around systemic risk or how we view the market as a whole for later, if anyone has those questions, or we can talk about them as a panel. But thanks again for having me.
So let me talk a little bit about securities law to start, but then I want to talk about regulation more generally in this space, because I think it's very important to think about context here. The way I got into this space was looking at things from a securities law perspective. We talk about cryptocurrencies, we talk about virtual currencies. A lot of people talk about blockchain tokens. And the reason we talk about blockchain tokens is because a representation of an asset on a blockchain, well, that's a digital asset that can be anything. So I hope I just blew your minds by that. But right, think about the power of being able to put anything on an immutable ledger where you know the provenance of that thing, so you don't have to worry that somebody's ripping you off when they sell it to you. That's a hugely powerful concept. And so when we talk about blockchain tokens, when I talk about blockchain tokens, I mean that in the broadest sense possible, in the sense that I just articulated, which blew your mind. But it raises interesting questions when you say it that way. And one of the interesting questions in the way that I got into this was whether or not these blockchain tokens were securities. And I won't go into all of the detail of the securities laws. There's definitions in the 33 Act and the 34, the Securities Act of 1933, the Securities Exchange Act of 1934, that define security. For some reason, they're slightly different, but the courts have said that they really mean the same thing. And securities are pretty broadly defined, although not as broadly defined as commodities are. And one facet of the definition of security is this term investment contract. So in addition to your ordinary equity securities like stocks and your ordinary fixed income or debt securities like bonds, there's this concept of investment contract. Well, certainly if a blockchain token is an equity security, we agree it's a security, and certainly if a blockchain token is a bond or a debt security, we agree that that's a security. But what does investment contract mean? The answer to that is found in a Supreme Court case from 1946. I can't remember if it's SEC against W.J. Howey or W.J. Howey against SEC. The basics of that case were W.J. Howey was a company that owned orange groves, and they sold interests in the orange groves. And they would be responsible for growing the oranges and selling them and sharing the profits with the people that they sold the interests to. The SEC said that's an investment contract, not the orange grove. The orange grove is not an investment contract. Oranges are not investment contracts, we hope. They're probably commodities.
Definitely commodities.
But the contract pursuant to which this profit sharing occurred is an investment contract. And how do we know that? We know that because it's an investment of money in a common enterprise with the expectation of profits solely, this is the Supreme Court's word, solely from the efforts of others. And actually, I shouldn't have given that away. I have two of my colleagues sitting over here. I should have quizzed them to make them give that answer. But so that's the framework that we're looking at when we're thinking about a token that is not an equity security, a token that's not a bond. Okay, so now you're going to say, well, wow, that sounds like a pretty broad definition. And I think the answer is probably yes, and we can get into sort of an interesting discussion about whether or not that definition of investment contract sort of swallows up the definition of most of the commodity interest contracts that you have. But the law is pretty clear that those things should stay separate. So we look at that definition, we evaluate the token based on the facts and circumstances. That's what the Supreme Court said. What's the answer? When is a blockchain token a security? Look, I don't know. I wrote a paper on the subject for Coinbase. I don't know if that's where you got your pricing from today, but it definitely went below 7,000 today.
Yep.
I've watched my Coinbase account nearly halved in value over the past 5 weeks.
It was all over the place. Yeah.
Yep. I was sort of feeling pretty wealthy at the beginning of January. I'm feeling much poorer.
Wait till tomorrow.
Yeah, indeed. So I encourage you all to take a look at the paper that we wrote with Coinbase. It's called the Securities Law Framework for Blockchain Tokens. It's available on the internet. They open sourced it. I'm not going to go into all of the gory detail around that, but it raises some really interesting questions under the federal securities laws that the SEC, Brian's colleagues at the SEC, are in the process of grappling with, and I think there's going to be some testimony in the Senate tomorrow by the chairman of the SEC and the chairman of the CFTC on this topic. The two chairs wrote an editorial in the Wall Street Journal recently that expressed some views on this. And Chairman Clayton from the SEC has been, I think, particularly aggressive in his view that there should be a lot of enforcement here and that a lot of these blockchain tokens are securities. I'm not going to dwell on that because I'm going to move to a higher level of abstraction here. Remember what I said at the beginning, not the shameless self-promotion part and not the part about how I'm a commodity, but right after that, about how a blockchain token can be a digital representation of any asset. Well, if we accept that proposition, and I think we do, that must mean that there are other important regulatory questions to be asked here, not just the question of, is it a commodity or is it a security? And those other important regulatory questions stem from the fact that blockchain is a technology, it's not an industry. And when we implement technologies in industries, that has regulatory implications in that industry. And so, for example, Robert was talking about energy world. So energy is actually pretty well regulated, right? FERC or something like that. So we have energy regulatory issues associated with Robert's example of people selling energy to each other. Healthcare is another place where I have a number of clients looking at blockchain implementations. Actually, some really cool stuff, like putting all of your health records on the blockchain so that you can make sure that you know who's seeing your health records and you're giving them to people. Very cool stuff. People are very creative here. But look, healthcare, we all know that that's a regulatory morass. And so when we think about regulation of blockchain in the healthcare industry, it's maybe an interesting question of whether or not the token is a commodity or a security or both. But there are a lot of other really interesting regulatory questions. So when you're thinking about regulation in this context, I really encourage everybody to remember that blockchain is a technology, remember that it gets implemented in different industries, and regulation often flows from where it's being implemented just as much as what it is. Maybe I'll leave you all with one final thought, which is this definition of virtual currency that the CFTC has articulated and a number of other regulators have articulated is a pretty broad definition. They say it's a means of exchange, a store of value, or a unit of account. Well, if you think about the world, think about something that's not a means of exchange, a store of value, or a method of account. So let's go back to the Howey case. Oranges, is that a store of value? I think I can make a pretty good argument that it is, until it goes rotten, right? So just in thinking about that definition, another area where I have done some thinking and speaking and writing is on this question of what is a virtual currency. And my personal view is that I think regulators are maybe defining it a little bit more broadly than common usage would indicate to us. Certainly if I was going to pay for that bottle of water with Bitcoin, I was using Bitcoin as a virtual currency, but it may have other uses that are not really what we would all sort of think of in common parlance as a currency. All of this is to say there's a ton of really interesting questions here for lawyers and for technologists and for everyday people and for businesses and industries. And there are lots of people who think blockchain is going to change the world. I don't know if I think it's going to change the whole world, but it certainly seems to have some really cool applications. And I'd love to listen to questions later and try to answer them.
I'm just curious, how many people, by a show of hands, think they really don't understand the distributed ledger technology? Does everybody here feel comfortable about it? They have no experience? Okay. Well, the good news is you actually know more than you do. Because, and I don't have enough time to do the full horse and pony presentation, but if you know how to use email, and you know how to use Excel spreadsheets, and you've ever bought stocks and bonds to an E-Trade account, you have the basic ingredients of everything that's going on in the distributed ledger, with one exception. In all those circumstances, email, Excel spreadsheets, and buying and selling stocks and bonds, okay, electronically, because you don't hold physical certificates anymore, nobody, everything is done electronically. The big difference is that somebody's running the show, okay? If it's email, maybe it's Google. If it's Excel, maybe it's Microsoft, or the people you've licensed this from. If it's from E-Trade, obviously it's E-Trade. Somebody's running the show. The beauty of the distributed ledger technology, whether it's the DLT associated with Bitcoin or Ether or Litecoin or you name it, nobody's running the show. Nobody's running the show. The show is running the show. It's the programming of the show through encryption, cryptography, all those good things that make it work. And although I think Robert suggested that the coin is unrelated to the technology, maybe it is, maybe it isn't. But the coin may have an integral part in how that system is kept together. What motivates people who otherwise have no reason to do anything to keep that system with integrity. So that's very, very important to me. The other thing I just want to make clear, because it's not always obvious, when Brian spoke about margin in the futures world, the problem in the United States is we have bifurcated regulation of futures and securities. Okay, we're probably the only major country in the world. Once upon a time, we had the most advanced regulation of financial services. Now, it's looking a little clouded. It's still pretty good, but we bifurcate. We say securities are under the SEC, and probably the states, 50 of them, last I looked, and futures are under the CFTC. And we use a lot of the same words in both industries, but they have very, very different meaning. When you buy something on margin in the securities world, you're borrowing money from somebody to buy your stock. In the futures world, margin simply is like a down payment that you've always got to keep. If you want to buy a futures contract, you've got to keep normally 2 to 3% of the notional value of the contract on deposit with your broker. And you daily have to adjust that amount to account for gains and losses. Okay. When Brian said 45%, that's an incredibly large amount of notional value of the contract. But the concept of margin is very different in the futures and securities, and that's very important. And then picking up on something that Lee has said, he couldn't be more correct that the nomenclature of this infant business that may have been launched too early is actually dictating the regulation of the business, okay? Because we started calling things from the beginning something, virtual currencies, digital tokens, it's almost driving the regulation irrelevant of what these things are. All these tokens, virtual currencies, you call it, are digital ledger entries. It's credits and debits or something on the blockchain, okay? They're nothing. They don't exist. We have made names for things that are just ledger entries. They have functionality, as Lee has suggested. Sometimes these ledger entries operate like a currency. Sometimes these ledger entries operate like a security. Sometimes these ledger entries do none of the above. They may be something called they may serve a utility purpose. It may be just like buying a ticket for the rides at Coney Island. Okay, they all serve different purposes. The problem is that the regulators think in terms of names. The regulators think in terms of names. So Lee is absolutely correct. If something is deemed a security, including an investment contract, the SEC says, it's mine, and I'm going to regulate it. Okay, And worse, what Lee didn't say, because he's an honorable guy, I'm not so honorable, is the SEC has not only said that guys who issue these tokens, which they deem to be securities, that not only are they going to go, and have they gone after these people, but they're going to go after the lawyers who advise them potentially. Okay? They're saying that if something looks like a security and you tell your client, not so sure, and it really is a security, you have liability. No cases yet, but Chairman Clayton has said that a couple of times. The states, the banking commissions, or the money transmitting commissions, or in New York State, the Department of Financial Services, they say that if a digital ledger entry operates like a currency, we're going to subject to our money transmitter rules. 50 states, 48 of them have clear money transmitter rules. They're all debating whether they should apply to this, but right now you have to assume they do. Okay, so money transmitter, if something is a virtual currency. FinCEN, the Financial Enforcement Network of the Department of Treasury, okay, they too say, since 2013, things like Bitcoin are virtual currencies. Virtual currencies fall within our jurisdiction. You engage in the purchase and sale of virtual currencies for a business. We want you to be licensed with us as a money service business. Okay, so FinCEN, states, SEC if it's a security, and IRS, of course, they think it's property, by the way. Buy and sell it, you get the tax treatment of property. And then CFTC, basically, if it's a commodity interest, meaning it's a derivative of some kind, based on a commodity, it falls within their jurisdiction. And as Brian said, certain leverage type of transactions. That's just the United States. You go outside the United States, there are countries that are truly scratching their heads what these products are because they don't have bifurcated regulation necessarily. They look at financial instruments as financial instruments, and they try to take a uniform approach to all financial instruments. Then there are countries that are in good faith trying to figure out how to regulate it within the framework of their existing approach, which is very different than the U.S. approach. And then, of course, you have jurisdictions that are just control freaks, and they really don't want anything that they can't control. So obviously, a decentralized ledger where people can move product on it and they have no control is horrifying to them. Hence, China. Okay, so the landscape regulatorily around the world, not just the United States, is very difficult right now and somewhat contradictory. Okay, Japan, for example, will tell you they don't look at these entries as securities. They under their local laws, they don't look at these as securities, but they may take what the SEC would consider to be a security, and they will say that it might be a virtual currency, and subject to their rules therefore. In the release that the CFTC, that Brian alluded to, that they released at the end of the year on actual delivery, there is a question 9. To me, it's my favorite part of the release, and it acknowledges that, or it suggests that sometimes securities may be virtual currencies. Think about that. If a security is a virtual currency, then it's going to touch all 5. It's going to touch FinCEN, the states, the SEC, the CFTC, potentially. Let me now go back. I'm the oldest guy here, I think. Back in the 1970s, this is a long time ago. Even I wasn't really conscious of it. No, but I did go to school then. Back in the 1970s, there was a development of a new product in the United States called commodity options. Commodity options, okay? Today, no one thinks twice about commodity options. Of course, commodity options are fine. They're okay. They're terrific. Everybody trades them. There's a big framework, not a problem. Back in the 1970s, early 1970s, it was very confusing. Nobody knew what commodity options were. Were they securities? Were they futures? But what happened was there was lots of fraud. Lots and lots of retail fraud. Goldstein-Samuelson, a major case, caused big problems, okay? The CFTC, nobody had jurisdiction over these guys because nobody knew what they were. It was one of the reasons why the Commodity Futures Trading Commission was created in 1974. And the Commodity Exchange Act was amended to include this very broad definition of commodity that's been alluded to a number of times here, so that commodity interest, at least, and commodity interest is simply a fancy way of saying effectively a derivative, on commodities would be under the jurisdiction of the CFTC. So good news is 1974 comes about, the CFTC now has jurisdiction over commodity options, no doubt about it, mostly. There's still some lingering court cases. For the next 3 years, the CFTC brought something like 25 to 30 injunctive actions in this space. Really bad people out there in the commodity options world. In 1977, the CFTC threw up its hand saying, we can't deal with this. It's too much for us. We're a small agency. We can't deal with this. We're asking for a suspension of all purchases and sale of commodity options in the United States until we can figure this out. Congress enacts that as part of law the following year. It wasn't until 1981 when the CFTC came back and said, okay, we now have a pilot program for commodity options, that the offer and sale of commodity options became lawful again in the United States. I personally am very fearful that the current path of confusion and regulation and the disruptive, what I call, I mean, Lee will tell you, DLT, digital tokens, disruptive technology. I say disruptive law. Disruptive technology equals disruptive law. We are a brand new territory right now, and I do have my concerns because there is a lot of retail fraud right now. Both the SEC and the CFTC have brought serious cases against people who are ripping off the public. And politically, Congress can't deal with that for too long. So to me, I'm hoping this stuff gets sorted out pretty quickly, because I do think, and I agree with Lee wholeheartedly, some of the ideas that have been suggested for the distributed ledger are phenomenal, okay? And it's a way of distribution of technology, of ideas that's unparalleled. One thing I also want to say is that you hear every so often about hacks, right? You hear hacks. Well, the key word that hasn't been mentioned today, the two key words that have been mentioned today as to one of the benefits of distributed ledger technology is peer-to-peer. You don't need intermediation. Okay, remember, Bitcoin came out in 2009 right as the financial crisis. Okay, right as Lehman Brothers was crashing, or the big firms were having problems. Here you had this decentralized thing that didn't require any intermediaries, because intermediaries were considered to be the weak spot of our financial system. Where have the hacks occurred today? Where are the breakdowns on the blockchains occurring today? At intermediaries. At folks who have tried to make it easier for people to access the blockchains. Okay, that's where the hacks have occurred. Just like in the non-DLT world. Okay, peer-to-peer, the transactions where people are acting together, one against another on the blockchain, no one's had a problem with those. No one's had problems with blockchain technologies. It's been the intermediation that has caused some of the problems. I'll leave it at that for now.